Hi, I'm John Kelly. I'm doing a 7-part series on vulnerable adults. In this chapter, we'll talk about immediate safety steps, reporting options like Adult Protective Services and Ombudsman. Facility cases can involve multiple legal theories. The best cases often do. Negligence is the first to cover. This is the baseline, failure to use reasonable care. Negligent supervision, negligent care, negligent staffing, negligent falls prevention are all types of negligence that we can plead. Now, some facilities' harm is truly medical. Wound care decisions, medication management decisions, failure to escalate to providers, failure to follow discharge instructions, failure to monitor a known condition. Depending on the state, medical malpractice has different procedural requirements. There's experts, affidavits, shorter deadlines, damage limitations, and so on. So you need to analyze early, and we are in mid-mal territory, negligence territory, or both is a question that you can ask your lawyer. Corporate negligence. This is where the story gets bigger than the one caregiver. Corporate negligence is about system failure. That is understaffing, the lack of training, poor hiring and retention, poor policies and culture that tolerates shortcuts. If the facility is chronically understaffed, that is not a random event. It is a decision. And if that decision foreseeably causes harm, corporate negligence becomes the spine of the case. Physical abuse and sexual abuse can implicate battery, assault, and intentional misconduct. These claims can change the case value and the emotional narrative, and sometimes open doors to punitive damages. Many states have statutes designed to protect elders and vulnerable adults, sometimes with enhanced remedies when neglect is reckless or when the conduct is particularly egregious. There isn't one set of statute that fits every state. Every state is a little bit different, but conceptually, these laws recognize something important. Abusing or neglecting a vulnerable adult is not just ordinary negligence, it is a betrayal of a special trust. When the neglect leads to death, the legal framework often includes a wrongful death claim. The family's losses is what that is, and the survival claims, the decedent's losses before death. And this is all depending on jurisdiction, how it's pled. There's a hard truth. In many facility cases, death is the defense's strategy. Not explicitly, of course, but practically. Because if the resident dies, the defense often assumes the case value drops. They were old, they were sick, they were going to die anyway. My job as an attorney is to burn that argument down with dignity and detail. Yes, they were old. Yes, they had conditions, and yes, they deserved safety, comfort, and basic care. They still had a life, and they did not deserve a preventable, painful death. So if you have a family member or a loved one that's a vulnerable adult and needs help or questions answered on a situation that we've discussed, we're happy to help. We do these cases around the nation. You can reach us at any time at 602-283-4122, the Kelly Law Team.